welcome to Crime and Court. My name is Heather, and this is another Idaho 4 update. We've got some docs that dropped recently, and I want to go through them. These are kind of some major ones, so let's see what happens. So, as always, please don't forget to like, comment, subscribe, do all the YouTube things. I appreciate it. Just your views, your likes, your subscribes, those are all free, and you can do that right now if you want. Thank you. All right, so we're going to go on to, we're going to read first the motion to close the hearings. This is a motion that was filed by the state. They want to close all the hearings about the, about everything, I think. They just want everything closed now. They don't want the public to find out what they're up to, I think. And then we're going to read through the defense's objection to that. Then we're going to read a motion to unseal parts of the IgG materials that was filed by the defense. And then we're going to read the response to notice of defendant's supplemental response to state's alibi demand. So, got a lot to read. Let's dive in. Let's get to it. All right, so the motion to close hearings pursuant to ICAR 32G and request for scheduling order comes now the state of Idaho by and through the Latah County prosecuting attorney requesting to close the May 14th, 2024 hearing regarding the defendant's fourth motion to compel and any hearing to be set for the defendant's fifth motion to compel. Why do you need the hearing closed? Usually, people who are doing the sealing or asking for closing of hearings and things like that, they're the ones that are hiding something. So what is the state hiding? This motion is made pursuant to Idaho Court Administrative Rule 32G and the likelihood that the state and the defense could be prejudiced by discussion or dissemination of information that has been stipulated to be filed under seal. And he cites a bunch of exhibits that he wants sealed. All of those exhibits. So, let's read them, I guess, because there might be something interesting in here. All right, so order sealing Exhibit A attached to the defendant's motion to compel, fourth motion to compel, fourth. Stipulated motion to file Exhibit D attached to the defendant's fifth supplemental request for discovery under seal. Defense request for discovery. Order to file defendant's Exhibit D attached to the defendant's fifth supplemental request or discovery under seal. Wow, this is a long one. Motion to temporarily seal Exhibit 1 of state's response to the defendant's fourth motion to compel discovery pending hearing. So that's a lot of exhibits that he wants sealed. And it is highly unusual for a case like Idaho 4 and Delphi to be sealing basically everything that they put forth. And I mean, we do get the filings, but we don't get exhibits. We don't get everything from Idaho 4. A lot of stuff that a lot of the back and forth between them is sealed, and we don't even get to know what they're talking about. All right, continuing on with the document, the state further motions the court for a hearing order setting May 3rd, 2024 for the defendant to file any notice of witnesses, exhibits, expert reports, and any other evidence that the defendant intends to rely on for the hearings regarding their fourth and fifth motions to compel. The state requests that the court afford the state an opportunity to respond to those initial disclosures, and such responses should be filed by May 10th. Ashley Jennings, Senior Deputy Prosecuting Attorney. I don't know. So that was e-filed when on April 23rd. That was filed. So the state wants to close any hearings regarding these motions to compel. So what is in those motions to compel? Or what's the discovery to compel is a good question. All right, so objection to state's motion to close hearings pursuant to blah, blah, blah. All right, so it comes now, Brian C. Koberger, by and through his attorneys of record, and hereby objects to the state's motion to close the hearing to compel on May 14th, 2024. So this one says May 3rd. Oh, it is the 14th. Okay, so we have one scheduled for the 14th, but then the state asked for a hearing for May 3rd. Okay. That's cleared up now. All right. The grounds are that Mr. Koberger has a constitutional right to a fair and public trial. No reason exists to prevent him from a public pre-trial proceeding, a proceeding to ensure fairness and access to the state's information. Further, the state has made no showing that the hearing should be closed under IAR 32. So why should it be closed? What good reason do you have to close these hearings? And they did not even provide a reason. All right, so there is simply no legitimate reason that a motion to compel discovery should be shielded from the public. The process of sealing is being abused by the state and its law enforcement agents, including the FBI, to hide how discovery is being withheld in this case. What? Let me read that again. There is simply no legitimate reason that a motion to compel discovery should be shielded from the public. The process of sealing is being abused by the state and its law enforcement agents, including the FBI, to hide how discovery is being withheld in this case. They don't want the public to know that they're not turning everything over. But we know that they aren't. We know. If anybody's following the case, we know. But they're really trying to hide it. All right, so testimony and argument on information sought by Mr. Koberger does not meet the narrow scope of what the state can shield from public view. Not only is there no authority to protect the FBI, other law enforcement agents, and the state in this matter, this request to deny Mr. Koberger an open hearing is a clear violation of his right to a public trial. Sealing of motion to suppress to protect privacy of witnesses was an error requiring remand for new public hearing. This is according to the sources that they're citing. All right, so the state has failed to provide all the requested items that were asked for in the defense's supplemental request for discovery to support the charges against Mr. Koberger. Thus, the defense has had to file its fourth and fifth motions to compel. It is not lost on Mr. Koberger that the state is asking for a scheduling order to obtain information from the defense to be used in support of our motions to compel the state discovery. So the state is trying to schedule an order sooner so that they can learn from the defense information that they can then file or put forth in their motions to compel the state's discovery. It is not lost on Mr. Koberger that the state is asking for a scheduling order to obtain information from the defense to be used in support of our motions to compel the state discovery. However, Mr. Koberger suggests a dual deadline for both the prosecution and defense to file notices of witnesses, exhibits, expert reports, and other evidence filed upon at the fourth and fifth motions to compel by May 7th. Response disclosures by both parties should be due May 10th. So 3 days to respond? I mean, that's pretty quick, but all right. So she's giving an alternate solution. Let's have dual deadlines for both the prosecution and the defense to file our notices of witnesses, exhibits, expert reports, and other evidence so that you're not getting my information first and using it against me in my own motion to compel, because that's what they're trying to do. Response disclosures by both parties 3 days later, May 10th. So that was the filing by Ann Taylor, objecting to sealing all of the hearings regarding the motion to compel. Here now is another filing from Ann Taylor, a motion to unseal parts of the IGG material. So, like I said in my thumbnail, the defense wants more transparency, obviously, and the state is trying to hide more and more. They're doubling down on their, let's not look at the evidence, let's just bury it solution. Comes now, Brian C. Kohberger, by and through his attorney of record, and hereby moves this court to unseal the IGG materials sealed by this court's order signed on 12/29/23, except for the individuals on the family tree or found via the IGG, on the grounds that this information should be made public and does not meet the requirements for sealing under ICAR 32. The court previously entered an order allowing specific members of the defense team, including specific experts, access to review the IGG materials it ordered disclosed. The court has indicated during hearings its concern was the privacy of individuals in the family tree. The defense shares that concern and takes no issue with it. The defense does object to the sealing of the rest of the information that has been disclosed. There is simply no legitimate reason that the way the IGG procedures in this case took place should be shielded from the public. So why is it being hidden? Is it because law enforcement maybe didn't follow accurate protocol? Maybe they broke their own protocol to get the information. Maybe that's why they don't want it coming out to the public. I don't know. But it's all very odd that the state wants to seal everything. The court provided no authority for sealing those materials. Most materials have been sealed in this case to protect the right to a fair trial. This is simply nothing unfairly prejudicial about the way in which IGG was carried about the state and its associates in this case. In point of fact, the way in which IGG occurred in this case has been made public in other cases. So what we're talking about has been made public in cases like the Golden State Killer, Joseph D'Angelo case. There's a link right there. Aspects of the IGG investigation in this case have already been leaked, according to this article, Brian Kohberger, University, Idaho, Unaliving's Forensic Genealogy. So there's already genealogy out there that's been leaked. How police actually cracked the Idaho and life endings case. So, that's the article that they're quoting there, and they give a link. The court's order is being abused by the state and the FBI to hide how IGG was used in this case, because what the FBI did violated its own rules and the rights of privacy genetic genealogy companies have promised. Not only is there no authority to protect the FBI and the state in this matter, this refusal to permit Mr. Kohberger to expose this to the public is a clear violation of his right to the public. I think Ann is done with Bill Thompson's BS. She's like, I'm done with you, and I'm coming forward, and I'm throwing some bombs, because we did not know this for a fact, and she puts it in a court document now that the FBI and the state went about ways to get genetic genealogy information from the companies, potentially illegally. The FBI did violate its own rules and the rights of privacy to the people. So, I mean, that's there now in black and white. We have it. It was always alluded to, but now we have it in black and white. So she's done with him. She's done with his shit. A hearing on this matter is requested if necessary. The hearing does not need to be sealed and is expected to take approximately 30 minutes if she has a chance to argue. Oh, this was Ann Taylor, Jay Weston for Ann Taylor. So he works with Ann Taylor. Jay Weston Logsdon, Chief Deputy Litigation Assigned Attorney. So he filed that. I mean, I agree. I think all this stuff needs to be unsealed, like all of it. Everything that the state's just trying to hide because they don't want stuff coming out to make them look bad. That's the only reason why things are getting sealed, in my opinion. All right, so now the final document that we're going to read through is the response to notice of defendant's supplemental response to state's alibi demand. So we got Bryan Kohberger's alibi. The media and a bunch of naysayers say, oh, his alibi was stargazing, when he didn't even say that at all. He said he was driving. He said on occasion he likes to run, stargaze, and like it listed a whole bunch of other things, or look at the stars. And then everybody, the media took that one phrase and said, oh, he was stargazing that night. No, that is not what happened. That is not what happened. I have a video in my on my channel. I will link it below if you want to read through Bryan Kohberger's second alibi, because the state is demanding his alibi be more narrowed down or something. I don't know. And now they're asking for even more information. So let's see what they say. Comes now the state of Idaho by and through the Latah County prosecuting attorney and submits the following initial response to the notice of defendant's supplemental response to state's alibi demand herein filed on April 17th, 2024. At the outset, the state incorporates by reference, as if fully set forth at this point, those portions of the state's July 27, 2023 motion to compel notice of defense of alibi, or alternatively to bar certain evidence to the extent that it relates to the adequacy and timeliness of the defendant's alibi notice. The state respectfully requests that the defendant's supplemental alibi response continues to lack the specificity required by Idaho Code 19519, which provides that the defense shall state the specific place or places at which the defendant claims to have been at the time of the alleged offense, and the names and addresses of the witnesses upon whom he intends to rely to establish such alibi. Bill Thompson, that's where I got Tom. Bill, I don't know how many more times they need to tell you that he was driving. There's no specific place. He was on the move. He wasn't in a specific place. So that may be the code. He was specifically, how's this? He was specifically in his car, which was driving around on the streets of Idaho and maybe Washington. Specifically, he was in his car in the driver's seat driving. How's that for you, Bill Thompson? Or Tom? I don't know. The defendant's April 17th, 2024 submission minimally adds to the alibi notice dated July 24th, 2023. The defendant states that he was driving around during the early morning hours of November 13th, 2022, and drove throughout the area south of Pullman, Washington, west of Moscow, in Idaho, including Wawawe Park, I think is how you say it. I don't know. With the exception of the reference to Wawawe Park, which is new, the defendant is offering nothing new to his initial alibi, that he was simply driving around during the morning hours. You were asking for specifics. He was specifically by this park. Like, what more do you want, Bill? As the state noted during the August 2023 hearing, the state is aware that the defendant was driving around rural areas of Whitman County, Washington, and Latah County, Idaho, during the early morning hours of November 13th, 2023. Yeah. In fact, the defendant's travels during that time are described in the original probable cause affidavit supporting the criminal complaint in this cause. Yeah, because you didn't do a sufficient job with the investigation or writing the probable cause. As to the defendant's reference to potential testimony about the location of the defendant's cell phone on the morning of November 13th, 2022, this information does not rise to the level of an alibi at the time of the homicides because the defendant's cell phone stopped reporting to the cellular network before the homicides and continued to not report until after the homicides. Well, Bill, that is why you bring in experts to debate his cell phone, his cell data. That's why you bring in experts. That's what she's talking about. It'll be proven through experts and other testimony from the witnesses that, maybe the clerk at, the mobile station over in the corners of blah, blah, and blah street, maybe they saw him. Maybe he had an interaction with somebody. I don't know. Like, those are the things that are going to come in through testimony and through witnesses. But he's saying that that's not sufficient. He wants all that information up front. So, like, everything that they're going to, everything that the defense has alibi-wise, he wants them to give him all their cards right now, instead of what most defense attorneys would do, which is hold their most valuable stuff close so that at trial you can drop your bomb and everything goes wild. The crowd goes wild and your client's released, hopefully. All right, so yeah, the location of the defendant's cell phone at times other than the time of the homicides is not proof or relevant to the defendant's specific location at the time of the homicides, approximately 4 to 4:30 a.m. The cell phone at times other than the time of the homicides is not proof. Non-proof is proof too, but the fact that, he was in such and such area and then the homicides are over here, how did he get from here to here in that time? Like, that can establish your trail, your timeline, where he was. I don't know. That's what the experts are for. It is the state's position that the defendant's continued failure to adequately comply with Idaho Code 195191 does not trigger a response under Idaho Code 2, whatever. If the court deems the defendant's supplemental response to be in compliance with the requirements of Idaho Code, the state requests additional time pursuant to Idaho Code 5 to pursue a list of witnesses to establish the defendant's presence at the scene of the homicides. As to witnesses to rebut a claim of alibi, the defendant's failure to adequately comply with Idaho Code means the state does not know what specific assertions it needs to rebut. If the court allows the defense to offer further witnesses or information regarding alibi, which the state opposes, as described below, and bring it into compliance with Idaho Code, the state will then respond accordingly pursuant to Idaho Code. It has now been approximately 11 months since the state filed its request for discovery disclosure alibi demand. So okay. So it's been 11 months since we requested this and we haven't gotten what we needed. Actually, you did, but you say it's not good enough. And then, how many motions to compel discovery has Anne filed for discovery in this case? I mean, come on. She had like a 14th motion to compel, and now I think that's what we were up to, 14. And now we're doing hearings for motions to compel because the state just doesn't want to turn stuff over, and it's ridiculous. But yet they're complaining that we didn't get something. So it's been approximately 11 months since the state filed its request for discovery disclosure alibi demand, and almost a year and a half since the homicides occurred. The defendant has been given more than more time than he is legally entitled to in order to provide his alibi, the state is substantially prejudiced and compromised in its ability to investigate and respond to new or additional alibi-related disclosures. Okay, maybe. I don't know. As the Idaho Court of Appeals noted in State v. Juarez, the state has a legitimate interest in obtaining timely and complete discovery response from the defendant. The state respectfully submits that we essentially remain in the same position as in July and August of 2023, and that, like Juarez, we don't know how this is an alibi at all. It's an alibi whether you want it to be an alibi or not. It's still an alibi, and you can dispute it all you want, Bill, but if that's where he was, that's where he was. Motion to compel notice of a defense of alibi or alternatively to bar certain evidence. The United States Supreme Court has observed in Taylor v. Illinois the ease with which an alibi can be fabricated, and the state's interest in protecting itself against the 11th hour defense is both obvious and legitimate. I don't think they're trying to bombard him with the 11th hour defense. I legitimately think he was driving, if that's his alibi. A lot of people do that at night when they can't sleep. I sleep, but I know that people do that. Anyways. Based on the above, the state respectfully requests that the court enter an order denying the defendant any further opportunity to add to any purported claim of alibi and preclude testimony by anyone other than the defendant as to the defendant's absence from or presence at the scene of the homicide. That I don't think that's constitutionally legal. Can you do that? I mean, if he doesn't want to take the stand, you're kind of tying his hand by saying it has to come from the defendant's mouth, not anybody else now. Bill is underhanded and diabolical, I'm going to say, to try to do something like that. First, you're trying to hide all of the stuff about the discovery in these motions to compel. You're hiding information. You don't want the public to know anything. You're stealing all the motions and everything that you can. You're trying to seal public hearings. And now you want no alibi from the defendant. You're saying the alibi you don't deem it worthy. So therefore, it's not an alibi and it can't come in. So the only way any kind of alibi information can come in is through the defendant, is what they're saying. And that's BS. Because the defendant has a right to remain silent. And that silence goes all the way out through the trial. If they get on the stand, that right goes away. Everything that they say on that stand is going to be free game for the state to attack. And will. So it's just, I mean, I get that he needs maybe a little bit more specific as into people, witnesses that she might be putting forth for the alibi. But at the same time, if that's her like smoking gun, why does she want to reveal that this early on? I feel like they're putting Brian Kohberger between a rock and a hard place by saying you can't bring in any alibi information unless it comes from the defendant's mouth. And I don't know if this is going to fly. I don't know if Judge is going to allow it, but he might say, yeah, you know, that alibi just isn't good enough and you've had your time and we're just going to go with the state's proposal. I would hope that he doesn't do that, but and I believe that Anne's going to have some things to say about this. So she's probably going to respond to his response. So we shall see what happens. Yeah, it's been a little more eventful for motions recently. So I just definitely wanted to give you this update and let you know what was going on in the Idaho 4 case. I don't like to get into the speculation and the theories, which is all everyone talks about regarding this case right now on the internet, on YouTube. I want to just look at the docs. I want to make the decisions for myself when I have the evidence in front of me. So hopefully, you know, at trial, I will make my decision. I'm still undecided, but if I had to decide right now, if I had to, Brian Koberger, unequivocally not guilty, because I haven't seen any evidence that really ties him to it. And everyone's going to say, what, the DNA? Well, I don't trust law enforcement just inherently. I question things. I question that DNA. I question the tiny, tiny little bit of DNA, how you got this big profile. And because it's like very tiny compared to even other tiny samples. So they had to multiply it. They destroyed it in the process. And I don't know. You can't tell me that it wasn't contaminated or it wasn't done in a way that was irresponsible. I'll just leave it at that. So and it was taken or compared to genealogy websites when it shouldn't have been, or not just that, but I mean illegally violating their own protocols into how to get DNA extractions. So therefore I don't trust inherently the evidence that law enforcement puts forth. I don't just trust it inherently, and neither should you. Nobody should. Don't trust police inherently. I mean, there are great police out there. They are wonderful men and women that go out and they risk their lives on the job. And they try to keep us safe, and we're grateful for that. But there are the minority of law enforcement officers that might be inclined to do something not necessarily on the up and up just to get the guy that they want, and we can't have that we have rules for when how things come into evidence. There's a chain of custody, and we can't be having law enforcement just make up their own rules as they go, because you and I could therefore be arrested and have our things illegally seized and all that just because a cop says so. So you can't just inherently trust. And that's my final thought for today, especially because the state wants to be more transparent. So usually when the person who is asking for the person who is asking for the sealing of things, that's the one who you want to look at more, because chances are there's something that they don't want seen. And with that, I will let you guys go. Thank you so much for watching. I really appreciate you, and I hope to see you in the next one. Don't forget to hit the like button on the way out. Take care. Thank you guys. Bye.
If you've been impacted by a true crime and would like your story told in your own words, or if you or someone you know has been wrongfully convicted or accused of a crime, please write to crimeincourtchannel@gmail.com and tell us your real true crime encounters. Thanks for watching.